Hey, this is Scott Shapiro with Remax Essential in Wilmington, North Carolina. Today I'm going to give you a 6-point tip talk on remedies to resolve any kind of survey boundary encroachments that are coming from a neighboring property. So after today's video, if you want free information on this, I'm happy to send you anything that I'm discussing with you. Just feel free to reach out whatever way is comfortable for you, whether it's a call, a text, an email, or a DM. I'm happy to respond anyway. But in North Carolina, I'm going to be focusing specifically on North Carolina state law. It's probably very similar in other states, but in North Carolina, if a neighboring property is encroaching onto your land, there are some legal potential remedies that you can use and utilize to help resolve these types of issues. Okay, so step number one is to confirm the encroachment. Now, this pertains to listings or owners that have inherited properties that want to verify if there are any encroachments. The easiest way to do this is by utilizing existing property maps, whether that's county plat maps, whether that's neighborhood plat maps, or even, more importantly, a in-hand survey that has been done on the property at some point in the past, preferably more recent. But if the survey doesn't exist, then it's probably important that you hire a licensed professional surveyor to not only mark the corners of the lot, but also confirm on paper if any structure or any type of fence encroaches, or driveway for that matter, encroaches onto your property. And step number two would be, let's communicate with the neighbor. Let's say if it's a house next door, there's probably somebody living there. And if you now have a survey in hand that confirms that there is an encroachment or are encroachments on the property, now you get to go next door and have a very informal, friendly conversation to kind of share your findings with the neighboring property owner. Hey, I just had a survey done on my property and I realized from the looks of it, your shed comes over my property 3.5, almost 4 feet. So we just wanted to make sure and verify this with you that you are aware, and we potentially might have you move your shed. Now, each property owner can decide however they want to proceed. I've had some buyers have a survey, have a conversation, get it in writing that both parties agree in writing that there's an encroachment on the property. So that way, if any time in the future the neighbor was requested to move that or resolve by removing the encroachment, that it would be agreed on by both parties that would happen with a request of written notice. So some buyers are okay with that. They don't necessarily want to disturb the neighbors, and they're happy that the shed comes over 3.5 feet on the property for now, but they've got it in writing, and everybody's aware of the situation. But in some other cases, you might have property owner that doesn't want anyone's property on crossing over their property line. So the informal conversation may be rejected by the neighboring property owner. They may dispute the encroachment and resolve that they're not going to do anything at all. So if that's the case, then and the informal talks fail, then your next step under communicating with your neighbor on step 2 would be ultimately to file a formal letter, probably certified mail is the best way to handle that. So that way you have detailed verification that the property owner next door has received notice that you have formally identified the encroachment, and now you're making them aware. So you can also make your demands in that letter as well, but it's a more formal conversation with the property owner that verifies in writing that they have received and acknowledge that they have received the information about the encroachment. Step number 3 is consider mediation. So mediation offers more of a neutral approach to resolving the matter. Now that you have the survey in hand and you've made the property owner next door aware, now you may have an attorney that has written a letter that formally states, we are aware of the property encroachments. These are North Carolina real estate laws surrounding surveys and encroachments, and these are the potential remedies that your neighboring property owner has the right to pursue. And so that typically would hopefully pressure the neighboring owner to follow through with the request to acknowledge and potentially resolve the encroachments. Okay, so that's where the mediation would be, and that would hopefully be the end of it, and that would resolve the issues. If not, then step number 4 is taking legal actions. And I'm going to give you 4 rough definitions that you can, again, talk with an attorney about, because I'm not giving legal advice. I'm just giving you the potential remedies here. One would be a quiet title of action, which is kind of asking the court to determine, the rightful ownership and boundaries. And now you have the survey to do that and to prove that. There's also a trespass claim. You can sue for unauthorized use of your land, where the owner has clearly taken a portion of your property and it's unauthorized and it's in writing. You can also look at ejectment, which is basically seeking the removal of the encroachment. And then in some cases, your declaratory judgment, which is requesting a legal ruling on property rights and obligations. So that should scare or pressure the owner, neighboring property who's encroaching on your land. It should pressure them enough to make a change or follow through with your request. If that fails, then step number 5 would be compensation and damages. So now, if that doesn't work, then you may be entitled to the cost of removal. So if you pay to have the fence removed and the driveway removed, you may ask for that money back that you spent on removing that encroachment. You can also sue for diminished loss of value, because you can't technically use the property that someone else is using. So that devalues your property. Loss of use, you can't use it if you don't own if you're not able to justly use all 100% of your property. And also, in some cases, and again, you can talk to an attorney, you might be able to sue for your legal fees, that whatever amount of money you spent on attorneys in court costs, then you can ask for that money back and potentially win in a case. But again, that's for an attorney to decide and the judges to judge. And then punitive damages, if the encroachment was intentional. Let's say the neighboring property owner knew the property lines, they've discussed it in the past, they've been notified about the property lines, and the neighbor just decided to go ahead and build their fence way over the line anyway and go ahead and put in a new brick driveway which crosses the property line. Then and it's proven that they were notified about before they started putting in the money or hiring a company to do the work, that they were notified that there was going to be an encroachment. That is exactly where you could potentially sue for punitive damages if you can prove it. Hopefully we'll never get to that case. So in step number 6, this is something that happens a lot more rare, but it is possible, and it is something that is real. It's called adverse possession. So preventing adverse possession in North Carolina simply means that you want to ensure that if you ever recognize anyone that's using your property, or that someone who's built a fence or built a shed over your property line, having a verbal conversation with someone is not going to justly protect your property rights. So the way you would need to do this is just ensure that you have something in writing that has both parties' acknowledgments that property owner next door has built a fence and a shed over my property line, and we both acknowledge and sign here as of this date that I'm aware that he or she is using my property. So if that is potentially not the case, and there's no written agreement or understanding acknowledgement that notifies both parties that the neighboring property is encroaching, then if that neighboring property owner who's been encroaching on your property is actually following through and using that property for a period of 20 years or more, and they can actually prove these fine points in court, they potentially could claim that property from you and adverse possession. So again, that's something an attorney can talk with you about, but I can also explain it a little deeper if you'd like some more info on that. But hopefully these tips kind of help, but it just comes down to being proactive well up front. Whether you're listing your home, make sure you've got a survey, or make sure you know where your property lines are. If there's a neighboring property owner who has a potential structure that's encroaching on your property, if there's any question, get the survey and do it before you list, so that way you can resolve that issue well in advance of any buyer contract, because then you're going to spend all that time and energy and marketing dollars on getting your home on the market, getting a contract, and then all to find out the buyer's going to walk away from the contract because there's an encroachment and the neighboring property owner refuses to resolve that dispute without going to court. If you're a buyer, more importantly, why you want to get a survey during your due diligence period so that you can avoid these types of issues. So anyways, hope this helps. Glad to talk to you guys anytime. Please reach out. Hope you have a great day. See ya.